Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a course which I'm delivering for the Buying Legal Council. This is a trade organisation for legal procurement, and I've been asked to present some basic information on civil litigation, which covers the common law and the English court system. This is all part of what we call the English legal system, and it's specifically relevant to England and Wales. It does not apply to Scotland or to Northern Ireland, which are both parts of the United Kingdom as well, but they have a separate jurisdiction. Let me explain a little bit about who I am and what this course is about. I'm a barrister at law practicing in London, and I spend most of my time on civil matters dealing with the three types of case we normally have now in the county courts, mainly, where there's no maximum jurisdiction anymore. That's the small claims, the fast track and the multi-track cases. Occasionally I will be in the High Court and sometimes in the Court of Appeal, but rarely in the Supreme Court because of the nature of my own practice. Let me start off by introducing the subject. English common law is probably the greatest legal system the world has seen. It evolved from customs which traders established, and after the Norman conquest of Britain in 1066, William I, the Duke of Normandy, set up the process for a common law system of justice based upon the concept of precedent, and it incorporated custom, based on effectively the conquered peoples and the way that the Anglo-Saxon law had developed. So there was a law already in place under Anglo-Saxon law, and he developed that based upon the creation of assizes and the distributing of justice around the towns by judges going on circuits. And by 1215, when the Norman invaders had become very established in Britain, the power of the monarch and those ruling the country was sealed in a document of rights, which we know as Magna Carta, which introduced the concept formally of the rule of law, which of course has now been in existence for some 800 years in the United Kingdom. And the position today is that Parliament remains the place responsible for the creation of legislation, which has precedence over case law authorities decided by the courts. And of course we do have the separation of the powers in this country between Parliament, which is the legislature, the executive, which is the government of the day, and the judiciary, which are the judges. And there is a strict split between the separation of powers, as there is in the United States of America. Now let me talk about the common law and what we call equity or fairness. Some litigants became dissatisfied with the rigidity of the common law system, and over the centuries a new system of equity emerged from the Lord Chancellor, who was a cleric and a very, very important and powerful person in the kingdom. He was keeper of the king's conscience. That was his actual title, and being religious, of course, it was a very important post to have. And he would dispense justice by being petitioned himself, and that became known as the Chancery Court. Now, by Victorian times, the courts had established that where a conflict between the common law and the principles of equity occurred, then equity would prevail. The concept of equity is, as I said, fairness, and it gave something more than just damages, in other words, a monetary compensation. It gave equitable remedies such as specific performance and so forth, which we know of today. Now, until the late 20th century, there were clear divisions between the common law courts and the equity courts, although these divisions have almost disappeared now as we see the introduction of online courts and artificial intelligence. And some of the newer courts today will be looking at a wide range of different remedies that are available to people. So we are no longer really looking at that strict definition, because it's about the common law legal principles or the equitable principles which must apply. Now let me move on from that to the court system in England and Wales. To many onlookers from outside, the court system in the United Kingdom looks a bit odd. The reason is based on historical differences between England and Wales, and Scotland and Northern Ireland. They all have separate jurisdictions, although the final appeal court is the United Kingdom Supreme Court, which is based in London and hears appeals from all jurisdictions. That is the model to which we are returning to at the present time. And for this course, and for what I'm doing today, I'm referring only to England and Wales as a jurisdiction based on the common law and equity. We have a concept of precedent where a higher court will make a decision which must then be followed by the lower courts or inferior courts under a doctrine of stare decisis, or the standing of decisions. Again, Latin tags, we don't really use them anymore, but they are still around occasionally. So the top court in the country is the United Kingdom Supreme Court. And it was, of course, known as the House of Lords Appellate Committee initially, but that's been changed with the creation of this new court, the Supreme Court, by Act of Parliament. Underneath that court is the Court of Appeal, which is separated into two divisions, the Civil Division and the Criminal Division. Now, underneath the Court of Appeal is what we call the High Court, based on in the Royal Courts of Justice in London. And the High Court has three divisions. The Queen's Bench Division, that's the old Monarch's Courts, if I can put it that way. The Chancery Division, that's the old Chancellor's, Lord Chancellor's Courts. And the Family Division, which of course by its name refers to family matters. These three divisions deal with civil matters primarily. The Criminal Court, which exists at the same level, is known as the Crown Court, sitting in particular towns. And they sit basically in all the main cities in the UK, in England and Wales. Again, in Scotland and Northern Ireland have different terms for something similar. But as I say, the Crown Courts are actually sitting in England and Wales. Now, underneath the High Court and the Crown Court are what are called the Inferior Courts, where in fact a very large amount of the business is done. For civil matters, it's the county courts or the family courts. And for criminal matters, it's the magistrates' courts or the youth courts. And all the courts are subject to their own detailed procedural rules and practice directions, which are complex and continually subject to change by the judiciary. And in fact, the White Book, which you may be able to see behind me, in the Red Book, those are some of the practice books. Now, the structure set out above, which I've explained, is a general simplification of the court system, because there are new courts which have been established for specific purposes recently, and there are other courts and tribunals, but I'm giving an overview. The most important of the new courts, of course, is known as the Business and Property Courts, and they're based in the Rolls Building, again in central London. Now, let me talk about those, because they may well be the courts that you, within your own activities, may need to go to, if either for arbitration or for a judicial decision. The Business and Property Courts were launched as a forward-looking measure, basically, by the government, and in fact the judiciary are the main movers of it. They were opened by the new Lord Chancellor David Lidington in the summer of 2017. Now, the United Kingdom is the largest specialist centre for the resolution of financial, business and property litigation in the world. And these new courts cover international dispute resolution jurisdictions, acting as a single umbrella for business specialist courts across England and Wales. And to give an indication of the change which is taking place in Britain, the new business and property courts encompass the following courts that we used to have, which you will obviously probably be aware of or have heard of. First is the Commercial Court. That includes the Admiralty Court and Circuit Commercial Court, formerly known as the Mercantile Court. Again, very old courts, in fact, some of these. Then there's the Technology and Construction Court, or the TCC. Finally, the courts of the Chancery Division, including those dealing with financial services, intellectual property, competition and insolvency. And again, very important courts in their own right. The beauty of the Rolls Building is that it's fully computerised, and going in there is rather different from the older courts that we have in the main royal courts of justice. We still wear wigs and gowns and do our business in our way, but in fact there's a lot of technology, a lot of computers, and it does make life a lot easier. That's the theory anyway, for all of us. Let me conclude by saying in this short course that the purpose behind this is there's a major programme for change as we approach the United Kingdom's exit from the European Union, which will probably be in March 2019. This is known as Brexit in this country. At present, the United Kingdom Supreme Court is actually subject to rulings from what is known as the Court of Justice of the European Union. That's the CJEU. Although it's envisaged that the UK Supreme Court will revert to being the final court for the United Kingdom once Britain leaves the EU. That has not been finally decided, but that is it is accepted that that is the decision that the British people arrived at when they took a momentous decision by a referendum to leave the EU, because it was that particular problem of a court in another country telling us in this country what to do, which provoked many people to feel that their sovereignty had been effectively attacked or taken away. So finally, let me say the era, of course, of the online courts is just beginning, with many proposed changes about to take place in the next 2 years. I've seen some of the courts in action in America and in Canada, and I can see that there's a lot of change with artificial intelligence to take place quite quickly. And at the present time, we don't know how these changes will affect the administration of justice, so the suggestion is watch this space, because there will be a lot of change in the future. Thank you for listening to me. As I say, this has been produced by the Buying Legal Council, and as I understand it, there will be some courses that they will be running. But I hope this is a helpful introduction for you if you have no real knowledge of how we do our legal business here in England and Wales. Thank you very much. It's recorded in the summer of 2017, this video. Bye-bye.